Did you want the sergeant sequestered during this testimony or?
Yes. No, you.
No, you don't give orders. You just don't.
Sorry.
You just don't. No, you don't.
It was a request.
No, it doesn't matter. Yeah, keep smiling. That won't end well. Go ahead, you can keep trying.
Okay.
The form of your questions are a problem.
Okay. At what point did you and I engage physically? Did you or your sergeant establish or discuss any probable cause to arrest me?
My sergeant gave us a directive to put you in the back of the patrol vehicle due to you obstructing our investigation. We were trying to assist your friend in getting medical attention. At that point, you were resisting. You put your hands onto the car, not the patrol vehicle, the car, and you clamped your
Okay.
arms together.
So, but hold up a second.
No, you cannot stop him. You ask the question, he's going to get to answer it. So you don't stop him. Go ahead.
My apologies, sir. May I finish, sir?
Go ahead. Yes, you may.
So at that point, you were resisting. So then we got the directive to detain you. And after you saw the sergeant gives another directive to place you in the back of the patrol vehicle for assault on a police officer. So I had multiple encounters with you putting your hands on. Yes.
Okay.
My sergeant asked you to place your hands behind your back. You did not do so. So we assisted you by placing your hands behind your back. You did not do so when you was placed against the vehicle.
So could you label where my obstruction was?
Your objection, asked and answered. I think he's been extremely clear about the different ways in which the defendant obstructed the investigation.
What investigation is what I'm trying to get to? We still don't have a corpus delicti, Your Honor.
Oh, I think we do, but that's okay. You think differently. I'll sustain the objection. You can try again, rephrase your question.
Under what investigation were you under?
Assisting your friend who was high intox.
Assisting high intox. Okay. Is that a normal police duty?
Yes.
Okay. Under those situations, is there ever a charge that would complement this?
Implement what?
Complement the assisting the high intox.
Okay, let's try to get this clear. You were there rendering medical assistance, potential medical assistance to the individual that was sitting on the ground,
Yes,
right?
sir.
Part of a police officer's duties, if they see someone that is in distress or in need of medical attention, would be to render aid. Is that correct?
Yes, sir.
And that's what you were doing that evening.
Yes, sir.
Okay, now we can move on.
Okay. What do you think my role was?
Your role in one, can you clarify for me, sir?
So you have one really intoxicated friend and then one that's trying to talk to you. At which point, or which role do you think I would be under when this investigation is going down?
I don't even know what that means. What do you mean role?
Your Honor, the officers showed up on the scene.
Yes.
There was no call for them to be there for me or my buddy. Okay, they showed up and they made themselves a part of our taxi ride home, and I got a charge for it.
No. Here's what happened. As like says, I can best determine. They're dispatched regarding a fight. They come across something else. It was somebody that may look like they need medical attention. As this officers testified, that's part of their obligation to render aid when it looks as though it's necessary. They were attempting to try to do so. Your intervention or role began to take place when you failed to follow the instruction of Sergeant Gibbs. That's what I have so far. So now you may go on to your next question.
Did you write your police report for that night? You did?
Yes.
You do that manually, or I'm sorry, on a computer, or do you handwrite them? Um, did you happen to write anybody else's? The report?
No.
No? Okay. Have you read the report recently?
Yes.
Have you read all of them?
Yes.
Do you find any similarities between them?
Objection, Your Honor. Relevance.
Good response to that?
Relevance there. I'm trying to figure out where these the relevance, they're all identical reports. It's pretty relevant. They were copied and pasted.
Maybe because they were all there.
And they all said exactly the same thing. What was the dispatch for? Okay. Seeing how that was, you agreed that that was part of your investigative duties to assist in my buddy's intoxication.
Well, I defer that question.
I know that. Okay.
So rephrase.
Let me rephrase. Would you agree that the reason that you and I met was because of alcohol?
Objection. Ask them.
Sustained.
What was the
Rephrase.
objection?
You heard the objection.
I didn't hear it. I'm sorry.
It was actually asked and answered, but it should have been relevance.
Yes, it could actually apply to both.
It does.
So,
Okay. Ask and answer. Is that what she said?
yes, rather clearly. It's about the fourth or fifth time that she's had to do that. So
Okay.
I would think five. Thank you, Mr. Kennedy.
To that night, saying anything to it, or just in general?
Yeah, just in general for right now. I'm just trying to figure out if there's it's like a rule or like a law that you might say with that would like get somebody kind of arrested me.
At that time, we see somebody that's obstruction to our investigation, we advise them to move along. If they do not move along, that's sometimes taken.
How much time do they have for that?
It was corrected by our sergeant.
Okay.
I think 3 times at least. So go ahead.
Let's take away that situation now and just a normal situation where you're investigating something and maybe your sergeant's not there. Okay. Is there a certain distance that someone has to be?
Yeah, I'm going to object, Mr. Relevance.
And-
This.
And speculation.
Answer.
Yes. Sustained. Rephrase your question.
You could tell me a safe distance that I would have been that day that would have satisfied you and your sergeant. I understand it was his command, but what is your opinion that would have been a safe
This
distance?
is irrelevant.
Opinion is relevant? That was it?
Did you not hear me?
I didn't.
Okay. It's irrelevant. It wasn't his command.
Could you clarify if you said that you seen me strike anybody?
Yeah.
Could you what? What's the question?
Clarify if the officer seen me strike or assault.
He's already answered that.
Um,
Well, assault's going to be another issue. But in terms of striking someone, he's already answered that.
Okay.
And I've also stated an objection from you asking it again to him. And here you go again.
if you could define at what point the probable cause was to detain me.
You didn't listen to my sergeant's directive. So he asked you to place your hand behind your back. You did not do that. You resisted that command.
When he said walk away,
No, you don't get to, excuse me, officer. You don't get to interrupt him in terms of his response. You ask the question, you let the witness answer.
trying to get clear.
Go ahead.
And then at that point, your hands were placed behind your back. You're actively resisting us to do so. And you place handcuffs.
Okay, within 30 seconds of being on the scene. Good afternoon. State your badge number for the record, please.
366.
366. Okay. You recall the events of October 11th.
Yes.
Have you had a chance to review any of the videos?
Yes.
I'm not going to bore us anymore. I'm going to really try to get to the point here.
Yes. So you're talking about detainment or arrest. So we got two different things going on.
Okay, so let's walk me through it. I was detained for.
You were detained for interfering.
Okay, interfering. What was I interfering?
You were interfering with my investigation, trying to help your friend who was extremely intoxicated. Yes.
Okay, trying to help my friend. Is that your lawful duty
Yes.
to help my friend?
Yes, to help. Yes.
Okay. Who ordered the HVA ambulance for?
Objection, relevance.
Stan, what's the relevance of that?
Good question.
I know.
Do you know under what law that would be?
I cannot say that off the top of my head. I'm sorry.
Okay.
It is definitely a lawful command. You're interfering. I asked several times.
You know if it says like a certain distance?
If what says a certain distance?
The regulation on the lawful command.
What regulation are you talking about?
My safe distance from my public's
Okay,
private space.
Mr. McGough, that's going to depend upon context.
Right.
It depends on what they're investigating. So what are you asking?
Right. At what distance would have been safe?
You can walk to the sidewalk. You just stay there. That's it. That's all I want. You didn't have to leave.
Man, that would have been so easy. That would have been so easy, right?
Oh, yeah.
Mm-hmm. Still trying to figure out this time though. I was first, right? There was no investigation. So at what point does investigating somebody else's drunkenness determine my arrest?
When I'm trying to assess a gentleman who's high intox and you're interfering with that, that's when that justifies that.
You're interfering with your, would you call it a civil act of checking on his welfare?
Oh,
Yes?
go ahead. You go ahead and answer.
Okay. So still no crime.
No.
You were just helping out.
It's
I
not illegal to be drunk in public.
Right.
Drunk and disorderly as you were. That's the problem.
okay. I was disorderly.
Yes, you were definitely disorderly.
Okay. I was disordering your investigation into the civil matter related to someone else.
Oh, I'm sorry. Say it one more time.
You said I was disorderly.
Yes, you were drunk.
So in the process, I was, because like it's under 40 seconds, right?
Okay.
So within 40 seconds, I didn't listen to your walk away when you're trying to investigate someone else's intoxicity and welfare. God bless you.
Objection is the form of the question.
It's a form of question. Knowing that there was no crime, would you agree that?
Or your friend,
Showing up on the scene, you guys were trying to get information about
a fight, an alleged fight.
a fight. Okay,
Once we saw there was no fight.
right, and it wasn't that.
I, your friend.
Right, drunk guy.
Yes.
Right,
The guy intoxicated.
let's take care of him.
Exactly.
Okay, so you're trying to take care of him. And what did you think I was doing?
Objection as to speculation.
Over.
Did I?
Let's hear.
What I think you were doing,
Yeah.
hindering, being obnoxious. to what you-
Okay. If
Wow.
if you never showed up, what do you think would have happened?
Objection speculation.
Sustained.
I just have a picture, Your Honor.
Of what?
Just the night in question, just a picture.
I would really like to see any exhibits
Just-
before you showed up to the court.
There you go. Just me.
Do you have a copy for me?
You can have that one.
Great.
Can I show them real quick? I just-
What?
Yeah, I'll give it to you.
No.
Sure.
What's it a picture of? And for what purpose am I seeing this picture?
Identification
Of who?
of me, what was going on before. These.
A picture, you gonna tell me all that? You got a picture and a picture.
Well, there's no other copy, Your Honor, so.
No, that's
I
fine.
would have sent it to you digitally, I got. I mean, can I do it? No.
So what do you
Man,
want?
here.
You want, are you gonna introduce that picture as evidence of something or try to?
Oh, I just, yeah, I'm gonna try to.
You're gonna try to. All right, let's have it marked. Defendant's Exhibit A.
It's just identification purposes, really. I see a confused look on your face. Before you guys arrived on the
Confused look.
scene. What was that?
What are you talking about? Who's confused? Look.
Oh, no, but it was, I
Oh,
was just,
trust me. I think
Everyone.
the sergeant knows more about identification of an object in court than you ever possibly will. So
Right.
I don't think he was confused at all,
oh, okay, yeah.
but appreciate your concern. Can we get that marked so we can get this
It
done?
is marked down.
Thank you. I'm sorry, Ann. I didn't mean to rush you, but sooner or later we gotta go home.
Yeah,
Okay. Witness has been marked as defendant's Exhibit A. Do you have a question, Harry?
do you recognize those two gentlemen?
Yes, sir.
Okay. If you could give your opinion of the two,
Objection foundation.
sorry,
Sustained.
what we're wearing, look familiar? That was the same night, would you agree?
Objection foundation.
Sustained.
Foundation. Um. I'm still trying to get to a crime that I committed, and this is before you showed up. This is, I was waiting on a ride, right?
Hold on a second. So the photo that you're showing is an.
It's just throwing out.
No, quit interrupting me. The photo, Defense Exhibit A, is a picture of events you know are prior to the sergeant getting there.
Right.
Then how's he gonna answer any questions about it?
Like I said, it was for identifications at first.
Of what?
Of the condition.
You've
of
already been
which-
identified.
The condition of us. I was the one, and I was. Yeah, but like I said, I know what happened, That
Okay,
night.
that's fine.
but I'm trying to prove it, and yeah, but you
Prove,
just
what are you trying to prove?
that not there was no crime.
That picture doesn't do it. I'm not going to accept the picture. You
Ypsilanti-
can't lay a foundation for that photo.
You're right. That was
I know
that
that.
was for identification, like I said, so we can just get rid of it.
So Defense Exhibit A is not admitted. Do you have a motion?
I do. To find over on count one as charged, assaulting, resisting, or obstructing Officer Darnell Tyson, reserve any further argument for rebuttal.
Response.
Your Honor, I under MCR 6110F, dismissal to lack of probable cause and insufficient evidence. there's no proof of any harm done. The officer that said I struck him, you know, he also said that I didn't, and he was just kidding. We all heard it. Didn't want to play it over again for some reason, but it was pretty clear what he said. And I appreciate the officer showing up to assist my friend with a highly intoxicated cause for investigation. But I do that does not warrant my detainment, much less my arrest. Yeah, and under MCR 6110F, dismissal lack of a probable cause, there was no probable cause. Anything after that is thrown out and inadmissible. It's under Matt versus Ohio.
Ms. Lundy, any response?
No, Your Honor.
Thank you. I don't really need it. Folks, give me 5 minutes. I'll come back with my decision on this.
I mean, I excuse the police officers, they've been here since before now.
Oh, no, they're going to be here as long as I am. No, they cannot go anywhere. What'd you say? I don't think that's what he said, but that's all right. First thing we said.
All right. Let me see. All right. 14A District Court for County of Washington, State of Michigan is back in session. The Honorable Judge Jason.
Thank you. You may be seated. All right. Having no additional argument in this case, the facts and circumstances of this case, the people with reference to count one, the charges as against Officer Tyson, the people have sustained their burden of showing that the offense of resisting and obstructing that officer, Officer Tyson, was done by the defendant on that date and at that time. Additionally, as the court can do pursuant to court rule and statute, court does believe that other offenses were committed during the course of this, which are 2 other additional charges of resisting and obstructing, specifically when starting, I guess, with what it will make count 2 with regard to Sergeant Gibbs, the failure to follow the sergeant's command. And I have to give the sergeant all the credit in the world that he gave continuous warnings for the defendant to remove himself from the area. The defendant then refused to do so. At the point at which also the defendant is being detained and put into handcuffs, there is sufficient testimony that at that point the defendant committed a separate offense of obstruction at that point in resisting the officers, and then ultimately the one to the kick to the groin of Officer Tyson. So those, in essence, constitute the 3 separate counts of resisting and obstructing. Therefore, the defendant is bound over to circuit court on those 3 charges.
Your Honor, can I ask a clarifying question so I make sure
Certainly.
I file the corrected amended information? The court found probable cause for added count 3 and resisting and obstructing, opposing, or endangering which officers? All 3?
Yes, all 3 officers. So
Thank you.
count 1 is referenced Officer Tyson. Count 2 is referencing Sergeant Gibbs. Count 3 is referencing Officer Smith. With regard to taking the defendant into custody and his resisting of the handcuffing, as well as, quite frankly, his resisting of, during the pat down, the refusal to acknowledge or respond to the officer's questions can constitute obstruction. So he is bound over on those 3 charges. Do you understand that, Mr. McGough.
Still argue the probable cause, but I'll let the paperwork from this point forward talk. Your Honor.
Pardon? What are you saying?
No questions over there.
All right. Do you wish to have the information presented to you and then arraigned on that information?
No.
All right, so you're waiving presentation and reading of that information?
Yes, sir.
All right. Defendant having waived presentation and reading of the information. And sir, what plea are you entering to those 3 counts?
I'm innocent, Your Honor.
Okay. Here are your choices. You can plead not guilty, you can plead guilty, or you can stand mute, say nothing, and the court will enter a not guilty plea for you. Out those 3 options, how would you like to plead to the 3 charges?
Stand mute.
Defendant having waived formal reading, standing mute to all 3 counts. Court will enter a not guilty plea as to all 3 counts. Pre-trial in this matter will be set for
April 3rd at 1:30 p.m. with Judge Slay.
April 3rd, 2025, 1:30 before Judge Slay.
May I have until noon tomorrow to submit signed amended information to the.
Yes, we'll hold the file.
Thank
And if you do that, that way the whole file can go up.
My goal will be by noon tomorrow.
Fantastic.
Previously, the defendant has accepted email service of motions, but the court be so kind as to make inquiries if they'll accept email service of the signed information.
Sir,
Emails, I can.
there'll be an information which is very similar to the complaint in this case. It will be signed off by the prosecutor based upon the court's rule. What the prosecutor is asking is, will you receive
Yeah,
an email and take that as service of your copy of the information?
yes, Your Honor.
All right, thank you. Great. Bond will continue.